Good afternoon, everyone. Welcome to the Myson Solicitors Presents Directors' Duties and Corporate Governance webinar on today, the 13th of April. I'm Ryan Fletcher. I'm a solicitor within the corporate commercial team here at Myson. Before we get into the talk, I'll just do a bit of housekeeping. So the webinar will be recorded and circulated to those of you that have attended today, and it'll also be posted on our YouTube channel. You will have noticed when you joined the meeting that your microphones and video were automatically placed on mute. I'll ask if you can keep them in mute for the duration of the webinar. There will be an opportunity to ask questions at the end of the talk. Again, I'll ask you to keep your microphones on mute and ask the questions through the Q&A function, which you'll be able to see on the taskbar for the Zoom call. You'll be able to ask me any questions in there, and that'll be answered hopefully at the end of the webinar. The presentation should last around about 30 minutes. And as I say, we'll have questions at the end just after that. So just a bit about me. I'm a solicitor in the corporate and commercial team here at Myson. I deal with mergers and acquisitions along with investment work, corporate restructuring and some banking and finance. My contact details are on the slide if anyone wants to get in touch after the talk to discuss anything that we've discussed within the talk or any other corporate matters that you may require assistance with. So the talk itself will provide an introduction to the UK corporate governance framework, and we'll have a particular focus on the general statutory duties of UK directors that are contained in the Companies Act 2006. So we'll get into the talk now. So when we consider corporate governance, the first question that we really need to ask is, what is corporate governance? On the slide there is the traditionally accepted definition of corporate governance, and that was given by the Cadbury Committee in 1992, following a number of corporate scandals that occurred in the 1980s and early 1990s. So in short, the UK has a market system that shareholders delegate company operations to the board. So directors on the board should operate the company day to day, but they should do so in the interest of stakeholders such as employees, shareholders, credits and suppliers. Corporate governance in the UK has developed to try to ensure companies are properly managed and includes measures to improve reporting, transparency and accountability. So in the UK, we don't have a single piece of corporate governance that exists. The UK has a series of overlapping regimes that form the overall corporate governance framework that applies to UK companies. Now, not all relevant regimes apply to all companies, but on the slide are some of the key UK corporate governance regimes. They are the UK Corporate Governance Code, which is often just referred to as the Code, which applies to UK quoted companies. Below that, there is the large private company reporting system, and that's a two-tier system that depends upon the size of a company. And that also incorporates what are called the weights principles. Now, the third and final key piece of corporate governance framework in the UK is statutory duties of directors, and we will have a particular focus on that during this talk, but I will just go through the first two before we jump into the statutory duties. So the UK Corporate Governance Code applies, as I've said, to UK quoted companies. This is issued and maintained by the Financial Reporting Council, and it operates on a series of principles that must be applied to a company. To the extent that a principle isn't applied by a company, then the company must explain why that's the case in an annual report. This is often referred to as comply or explain. What this means is that the UK Corporate Governance Code isn't strictly law, but quasi-law or soft law. And that's intended to allow flexibility if there's a need to deviate from the code where appropriate. For example, if it wouldn't be cost effective or counterproductive to comply, a company can. They just need to explain why it's the case that they haven't applied the relevant principles of the code in relation to that decision. Now, again, the code only applies to UK quoted companies. And as the intention of this talk is to focus on small and medium-sized enterprises and owner-managed businesses, we won't consider it in more detail, but it is useful to consider to have a rounded understanding of UK corporate governance. So the second bullet point on that slide is large private company reporting. What this means is that large companies of specific size are required to produce annual statements pursuant to the company's miscellaneous reporting regulations 2018. As it says on the slide, it's a two-tier system, and that's based on a number of factors, including employees' turnover and balance sheet value. So companies with over 2,000 employees or a turnover of more than 200 million and a balance sheet total of more than 2 billion are required to provide a statement of corporate governance arrangements. Slightly smaller, large private companies with a turnover of more than 36 million or a balance sheet total of more than 18 million or more than 250 employees are required to provide an annual statement on engagement with suppliers, customers, and various other stakeholders. Now, in addition to those, any UK company that is required to provide a strategic report, be it under the code or the large private company reporting requirements, is also required to produce what's called a Section 172 statement. And what that does, it explains how directors have regard to their duty to promote the success of the company under Section 172 of the Companies Act. Now, I will cover off Section 172 of the Companies Act in a bit more detail later in the talk. In addition to the reporting requirements, the weights principles have also been developed alongside these. What they do is provide a framework for large private companies to make appropriate disclosures about their corporate governance arrangements. There are a number of principles. In short, they are purpose and leadership, board composition, director responsibilities, opportunity and risk, remuneration, and stakeholder relationships and engagement. Now, these are a useful touch point for any company that is looking to voluntarily implement a corporate governance structure or perhaps implement some systems of corporate governance within smaller businesses, as they can be voluntarily applied to demonstrate good corporate governance. And I will touch upon voluntary corporate governance towards the end of the talk. So the third and final bullet point on that slide is statutory duties of directors. So as no doubt most of you, if not all of you, will be aware, if you are directors of UK companies, all directors of all UK companies are subject to the statutory duties contained in the Companies Act 2006. There are other statutory duties elsewhere, but we will be generally focusing upon the Companies Act today. So directors' duties form part of the overall corporate governance framework. And what I'll now do is I'll walk you through each of those duties individually. So on the slide, you'll be able to see the key duties that directors are subject to pursuant to the Companies Act 2006. So the list on the screen is a summary of the general duties. It isn't exhaustive of all duties, but it is a summary of general duties within the Companies Act. There are a number of other duties that must be observed in connection with the role of a director. For instance, filing accounts, ensuring compliance with a wide variety of laws and regulations, such as areas relating to insolvency, health and safety, and a number of other areas. Some are contained in the Companies Act, some are contained elsewhere. Now, in the context of the duties listed on the slide, the circumstances and context in which a director acts are relevant when applying the duties, and there are therefore specific standards that apply to each duty. Duties are owed to the company, and only the company can enforce them. So they aren't enforceable by shareholders as such. However, shareholders can, in certain circumstances, bring a claim on the company's behalf if there is an alleged breach of duty by a director or directors. That's often referred to as a derivative claim, and anyone that needs specific advice in relation to that, I would urge to get in touch with our commercial litigation team, who specialise in claims of that nature. One other question that we're often asked in relation to directors' duties is whether or not they can in any way be diluted or avoided, possibly. Articles of association or agreements between shareholders and directors may supplement the duties contained in the Act, but they can't exclude or dilute them in any way. So it's not possible really to abrogate your responsibility as a director. So if we just turn to each of the duties in turn, I'll run through it in a bit more detail with you. So a director of a company must act in accordance with the company's constitution and only exercise their powers for the purposes for which they've been conferred. Now you'll see on the slide there that there's a reference to the constitution in the first bullet point. Now it's important to consider what that means in the context of this duty. So constitution itself is very widely construed. It wouldn't just be limited to the company's articles of association, but it would include shareholders' agreements or any other relevant agreement or arrangement. The second bullet point is important in the context of this duty to consider what it actually means when acting as a director and acting within one's powers. So only exercising powers for which they are conferred isn't actually clarified within the Act. So it's necessary to consider case law in the context of what this means. So the leading decision on this area is from a 2015 case in the Supreme Court, which shows that exercising powers for their purpose isn't concerned with excess of power, but by doing an act which is beyond the scope of the power granted, so an abuse of power, and by doing acts which are within its scope, but done for an improper reason. So if I just give you an example of what that would mean, in this case, directors had used the power to restrict votes of certain shareholders due to what they said was a failure by those shareholders to comply with a request for information from the board. The reality was that directors utilised this power to prevent those shareholders from voting and influencing the outcome of resolutions at a general meeting. So this was found to be an abuse of power and therefore a breach of the duty to act within powers. The reason for this was that whilst directors had the ability to restrict the right to vote due to a failure to provide the requested information, the reality is that the power wasn't used for this purpose, but it was used purely to stop them from voting, and therefore it wasn't used for the purpose for which it was conferred. So when acting within one's powers, one must ensure that the powers are used for their proper purpose, rather than acting outside of those powers in order to comply with this duty. So I've already referenced section 172 earlier on when talking about the corporate governance framework and reporting requirements for large private companies and UK quoted companies. So under section 172 of the Companies Act, a director is required to act in a way they consider in good faith will be most likely to promote the success of the company for the benefit of its members as a whole. So this duty is often viewed as a cornerstone of corporate governance. As I've said, it forms part of the requirement to give corporate governance reports produced by large private companies and quoted companies each year. This isn't a requirement for SMEs, as I mentioned, but it can be voluntarily implemented if that is desirable. So the duty applies to all decisions made by a director, not merely formal decisions made by the whole board. So the Companies Act contains a list of factors which can be seen on the second bullet point that a director should have regard to in the context of section 172. If you consider each of the bullet points listed underneath the second bullet point on the slide, you will note that there is a focus on stakeholders, not just maximising profit in order to comply with this duty. So the list of factors on that slide isn't exhaustive, however. Directors should have regard to other matters that are relevant to this duty when applying it. The duty itself is subject to a requirement for directors to consider or act in the interest of the creditors of the company in certain circumstances. So accordingly, the duty can be displaced when the company is insolvent, and it can also be displaced prior to insolvency if a director should have regard to the interest of creditors as a company nears insolvency. So I will touch upon duties in the context of insolvency as well later on in the talk. So the third duty here is to exercise independent judgment, which means a director of a company must exercise independent judgment, and the duty can be viewed as an obligation for a director to exercise powers independently without subordinating their powers to the will of others. So a strict reading of this duty means a director couldn't agree with a third person, such as an appointing shareholder, for instance, to vote at board meetings in any particular way. However, as per the first bullet point and the second bullet point, this wouldn't be the case if the company's constitution allowed it. So for instance, if the articles contain a specific allowance for an arrangement of this nature, as such, the key takeaway here is that it's important to ensure any powers of delegation that are required are expressly set out in a company's articles of association. It's also important to note in the context of this duty that it won't prevent you as a director from relying upon professional advice, so long as you then exercise your own judgment in deciding whether or not to follow the advice. So a director of a company must exercise reasonable care, skill, and diligence. What this means is a director must exercise this care, skill, and diligence that would be exercised by a reasonably diligent person with both of the standards listed on the slide. So you'll note there that there are two standards under the second bullet point. The first standard listed is an objective test, and the second standard is a subjective test. What this means is that at a minimum, a director must display the knowledge, skill, and experience set out in the objective standard. But where a director has specialist knowledge or particularly skilled experience, then the highest subjective standard must be met. So this is relevant where you work in a high skill sector or if the director in question has a degree of knowledge that a lay person wouldn't have. So in applying the test, regard must be had to the particular director's functions, including their specific responsibilities and the company's circumstances. If a director for any reason doubts their own ability to take on a particular role, then this duty is important, as it means that they should make sure that in accepting the office, they aren't accepting responsibilities that they'll be unable to discharge. And delegation here isn't by any means a safe harbor. So that objective test that's listed means that directors have an obligation to have and maintain a level of knowledge, skills, and experience that a person carrying out that role would be expected to have. So ignorance isn't a defense for a failure to comply with this duty. To the extent that a director is lacking in knowledge, skill, or experience, they should take steps to rectify this, such as through research or further education, and that could be something as simple as attending a talk of this nature in order to consider what one's duties are as a director in more detail. In the context of this duty as well, a director will be required to exercise their duties diligently, keep themselves informed about the company's affairs, and join with co-directors in supervising and controlling them. So this won't prevent a director from relying on the experience and expertise of their colleagues, or generally prevent sensible delegation or a division of tasks, provided that a director doesn't attempt to abrogate all responsibility in the context of this duty. So it is a bit of a balancing act. This next slide is talking about conflicts of interest. So a director of a company must avoid a situation in which he has or can have a direct or indirect interest that conflicts or possibly may conflict with the interests of the company. So this applies in particular to the exploitation of any property, information, or opportunity. And it's important to note that it is immaterial whether the company could take advantage of the property, information, or opportunity in the context of this duty to avoid conflicts of interest. So the test of whether or not this duty is breached is objective, and it does not require awareness of a director in order for them to be in breach of the duty. Now, usefully, the Companies Act does contain some examples of when the duty will not be infringed, and that includes if the situation can't reasonably be regarded as likely to give rise to a conflict of interest. So an example would be a director exploiting an opportunity that has been formally declined by the company, presuming that the company's own decision was fully informed and properly taken. And the way that that would be documented is that a board meeting should be held to note the opportunity and note that the company isn't willing to pursue it, and therefore another director would be able to pursue that opportunity themselves. Another scenario is that if authorization has been given by directors who are genuinely independent, so in other words, a potential conflict of interest has been noted and proposed and brought to the attention of the board of directors, and everyone else on the board or a quorum of directors has voted to say that they are aware of the interest and that the interest is approved in the context of this duty. And that would still have to be carried out in a proper way. So each of the directors themselves that are approving the conflict would have to have no direct or indirect interest in the transaction or in approving the conflict. So another opportunity is that authorization may be given by the board, as I've just mentioned, unless the company's constitution invalidates such authorization. So when approving any potential conflict of interest, it is a case of there isn't a one size fits all here, and the company's own articles should be considered when looking to approve any form of conflict of interest. So directors mustn't accept any benefit from a third party, which is conferred because of their position as a director or as a result of them doing or not doing anything as a director. So on the face of it, this is relatively self-explanatory. It's intended to prohibit the exploitation of a directorship for personal benefit. So the obvious application here is some form of bribe, but its application is wider by reference to the word benefit within the duty itself. So what actually consists of a benefit in the context of the duty not to accept benefits from third parties isn't actually defined anywhere within the Companies Act. So it has been considered that the appropriate definition is the dictionary definition of benefit. So this could therefore include a favourable or helpful factor, circumstance, advantage, or profit. So it can be quite widely construed as to what a benefit would be, and it could include something as simple as being given information. It doesn't have to be monetary in nature in order for that to be a benefit from a third party. So if we move on to the final duty here, and that's to declare an interest in proposed transactions or arrangements. Now, there is an interplay here with the duty to avoid conflicts of interest. For this duty to apply, the director need not be a party to the transaction in question. So any interest in a proposed transaction or arrangement from a director must be declared, and that declaration must be made before the company enters into the transaction or arrangement. This should be declared and recorded either in board minutes or via a formal written notice to the company to ensure that there is a record of such declaration. And that would be to protect both the director and also the company itself. So the duty is ongoing. So if an earlier declaration subsequently becomes inaccurate or it has to be updated for any reason, then a further declaration should be made by the relevant director or directors. If a director has an interest and a meeting is held to consider the matter in question, then you need to make sure that you pay careful attention to the company's quorum and voting provisions within its articles of association. It's not possible for me to say here what the requirements will be, as each company will have a different set of articles, unless they've adopted model articles. And even then, it should be a case of ensuring what the quorum requirements and voting provisions are and applying them, as it may well be that an interested director is prevented from forming part of a quorum or from voting. They may also be prevented from attending a board meeting at which their interest is to be considered, or they may be permitted to attend. It really depends upon what's in your articles of association. In terms of the way that this duty works with regard to direct and indirect interests, you'll note the reference to indirect interest within the first line of the duty. Now, an indirect interest isn't defined within the Companies Act, but it is likely to include the interest of any person connected with a director. So that would include any family members, any corporate entities that that director has an interest in as a shareholder or potentially as a director as well. And it would also include any trust arrangements or other corporate entities that the director is related to. So again, you need to have regard to not only your own interests, but those of your potential family members. In terms of making a director's declaration, in certain circumstances, it won't be required in the context of this duty. So examples of when that's the case is where the director isn't aware of their interest or where the director isn't aware of the transaction or arrangement. However, you need to tread carefully in relation to this exception, as a director will be treated as being aware of matters of which they ought reasonably to be aware. So ignorance isn't always a defence here in the context of this duty. Another example of when a declaration isn't required is if the interest can't reasonably be regarded as likely to give rise to a conflict of interest, if the other directors are already aware of it, or if it concerns the terms of the director's service contract to be considered by the board. Another example of when a declaration will not be required is if the company has only one director. So if you are the sole director of your company, you already know as the sole director about your potential interest in the matter, and therefore you wouldn't need to formally declare it because you are yourself aware of it. So those are each of the duties within the Companies Act, the key duties that you would need to consider. There are, as I've mentioned, a number of other statutory duties that are relevant in the context of your role as a director. So examples are those listed on the slide. So Insolvency Act, Health and Safety and Environmental Regulations. In terms of the Insolvency Act, wrongful trading is if during an insolvent winding up or an insolvent administration, a current or possibly a former director knew or ought to have concluded before the commencement of the liquidation or administration that there was no reasonable prospect that the company would avoid going into insolvent liquidation or insolvent administration, then it may be possible for a court to make a declaration that the director has to contribute to the company's assets. That would be a personal liability as a director. So it is important to have regard to that duty, as failure to comply could ultimately hit you in your pocket. Fraudulent trading is also relevant as well here, in that if during a winding up or administration, it appears that any business of the company has been carried on with the intent to defraud creditors or for any other fraudulent purpose, a court may declare that anyone who was knowingly party to the fraudulent business contribute to the company's assets. So again, that's a potential personal financial penalty. The third point under the Insolvency Act of misfeasance or breach of duty means that if during a winding up it appears that a current or former director has misapplied any property or money of the company or retained any property or money of the company, then the court may order the director to repay, restore, or account for the money or property with interest or contribute such sum to the company's assets. So again, that's a potential personal liability subject to a court order. Health and safety regulations can include an obligation, can include a criminal liability for a director, because they can be held criminally responsible for health and safety offences where the company itself is found guilty of a health and safety offence, or the offence was committed with the consent or connivance of, or was attributable to any neglect on the part of the director. There are a number of other health and safety regulations, but that's one of the key ones because obviously a criminal penalty could ultimately result in a custodial sentence. The third point there is environmental regulations. These are quite wide and it's not really appropriate to summarize those here. However, they're already quite wide and it's quite likely that these areas will grow over time because of the obvious political climate in which we all are. So it is important to be mindful of one's duties as a director outside of the Companies Act. And again, this is just a snapshot of some of the potential duties that do apply. So we're getting towards the end of the talk now. You'll recall at the start that I did reference potential opportunities for corporate governance in owner-managed businesses and SMEs. So as I mentioned at the beginning of the talk, there are no specific legal requirements for corporate governance reporting in SMEs beyond compliance with the Companies Act, and in particular, Section 172 Directors' duties to implement any formal corporate governance arrangements. On the slide, however, is a list of some examples of how to potentially implement a voluntary corporate governance framework. So I'll go through each of the bullet points just to give you an example of what that could include. So a corporate strategy can be something as simple as maintaining a business plan and using it. So it's quite likely that a number of you have, or all of you have produced business plans in relation to your respective businesses, and hopefully that business plan is reviewed and maintained. If not, then it is often useful to keep the business plan and continue to maintain it over a number of years, and that might be split over 1, 3, and 5 years or longer, so that there's a clear vision of where the business is, where you want it to be, and how to get there. In the context of long-term visions, a risk register is useful, as what it can do is it contain a description of the main risks that may face the company. It would also then cover off the impact if that event were to occur, the probability or likelihood that it will occur, and what your planned response would be should it occur. You may also want to cover off actions that you can take in advance in order to reduce or mitigate the probability or impact of the event occurring. So the third bullet point there is talking about regular board meetings. You'll note throughout the talk I've referenced board meetings in the context of certain directors' duties or giving approvals in the context of certain directors' duties. So having a regular board meeting can be useful in the context of directors' duties, but also in the context of corporate governance as a whole. So you may well be aware that in certain circumstances, articles and shareholders agreement may stipulate a requirement for regular board meetings. If you haven't considered this, it is best to check. And even if it's not, there is a benefit to having a formal board meeting between directors to record decisions. So it could be that this is just once a quarter, once every 6 months, but meetings should be held and should be minuted in order to record decisions and authority for directors to carry out actions on behalf of the company. In terms of decision making, reporting lines is important. So what is the internal structure of your business? And all staff should know who to report to, and this should ultimately lead always to the board of directors. Any powers of the board that are delegated to an individual or committee should be recorded, including the powers granted and the term for which the powers are to be delegated. It should also be considered how decisions are made. So this needs to be clearly understood by all, and all decisions should be recorded. And again, this goes back to the point of having regular board meetings and recording decisions of a company. The third to last bullet point there references having bespoke articles of association. So if you have a company that's operating on standard articles or model articles or just the articles that it was given upon incorporation by an incorporation agent or whoever else, and without a shareholders agreement, then you should carefully consider this arrangement. So beyond a startup or a very small business or a business owned by one individual, a company would likely benefit from having bespoke articles of association to reflect its structure and how it's actually operated on a day-to-day basis. It may also be appropriate to have a shareholders agreement depending upon the structure of your company, and it would probably be beneficial to discuss this with a solicitor to advise upon both. Once you have appropriate articles in place and possibly a shareholders agreement as well, you should then use them. It shouldn't just be a case of paying for them and then putting them in a drawer. They should be regularly considered and revisited on all important decisions of the company at all areas in which corporate governance is relevant. So the second to last point there is non-executive directors. Now, this is probably something that might not be appropriate for relatively small businesses, but as a company grows, more focus will be placed on the board. And so the composition and competence of your board will need to change to reflect this. So introducing external or independent voices can often help positively challenge how the company operates. And you'll often find that if you come through to an investment round, that this will happen in any event. So the final bullet point there is talking about the weights principles, which you may recall I referenced at the start when explaining what the UK corporate governance framework is. Now, as I said at the start, the weights principles can be used voluntarily, and it is useful to have regard to them when considering how best to implement and maintain a corporate governance system. They do have very simple principles, and they can be applied across the board, regardless of how large or small a company is. So one of the questions we are often asked in the context of this is, what are the benefits to voluntary corporate governance at an early stage of a company? Really, it can help organizations achieve long-term success and value creation. So this applies to all organizations of all shapes and sizes. The earlier a company begins to give mind to these structures, the easier implementation can be. So good corporate governance can help bring in outside expertise, it can attract investment and funding opportunities, and it can ensure long-term sustainability as well. So if we were all in a room now, I would ask if anyone has actually been through an investment round with a private equity fund. But as we're not, I'll just say generally that anyone who has been through an investment round with a private equity fund will be aware of the often steep curve that has to be met after the investment in relation to corporate governance. So things such as reporting, authority, consent, compliance are all key, as well as board composition. Private equity will also consider building up a management team around the founders, and that will form part of the development of corporate governance to try to ensure that ultimately your business can operate without you or with minimal input from you. If you've already implemented some or all of this before the investment round, then this will help you and your business. So the final point I just want to touch on very briefly is directors and officers insurance. So as directors can be personally liable for the actions that they carry out as directors, then it may be beneficial to consider maintaining directors and officers insurance to cover any potential legal costs or financial penalties that may arise in the course of a director dispensing their duties. So directors and officers insurance can cover each of the matters listed on the slide here. Any insurance should obviously be discussed with a broker who specialises in cover of this nature, because it is something that needs to be tailored to one's own business. Any policy is likely to be subject to specific exclusions, such as fraud, dishonesty, and illegality, amongst a number of other matters. So as I say, I just wanted to touch upon that as a potential option for you. So we've come to the end of the talk now. I can see that there are a few questions in the Q&A function. I'll just give a couple of seconds in case anyone else wants to add anything in. Okay, so some of the questions that have been submitted are asking about what happens in the context of non-executive directors. So if one is a director, one has the duties of a director. For the purposes of the Companies Act, there is no distinction between executive and non-executive directors. So if you are a non-executive director, you are still subject to those duties within the Companies Act and with the other duties that I have referenced elsewhere. So it is important to obviously have mind to them and bear that in mind when taking on or considering the opportunities given in the context of a non-executive directorship. In the context of directors and officers insurance, there's a question here about if a company is arranging directors and officers insurance, do the articles or memorandum have to permit this? It's a case of having to have authorization in place. So if it's already within your articles, then obviously the authority is there. If there's nothing within the articles, so long as there's nothing within the articles that prohibits the company paying for directors and officers insurance, there would be nothing to prevent that from being taken out. However, what would be appropriate is to hold a board meeting in order to consider the directors and officers insurance and providing authority to the directors to put that insurance in place. But it wouldn't be strictly necessary to have something within your articles to permit this. And then there's one final question, which is talking about increases in actions for wrongful trading. Yeah, it's a good question. It's a bit of a finger in the air question, to be honest. It is potentially an issue that might arise. Obviously, wrongful trading would only arise in the context of if someone was wrongfully trading when they knowingly are aware that the company is insolvent or likely to become insolvent very soon and continues to do nothing about it. There is a risk that it could arise more. However, in our experience, whilst insolvency, there is a potential for insolvency, the corporate market, mergers and acquisitions, investment is all still relatively buoyant and hasn't really been slowed down that much, save for perhaps the first few, maybe the second quarter of 2020. Nothing has really slowed down, so everything is still looking relatively positive at the moment from where I'm sat in the terms of corporate acquisitions and investments. So whether or not insolvency is on the rise is a different matter, I suppose. So I think that's all the questions really we've got time for now. So this webinar is being recorded and it will be circulated to you later today. If anyone has any further questions or would like to discuss anything in a bit more detail, again, my details are on the screen, so feel free to get in touch with me. But thanks for attending today.